The provisions in Section 304B of the IPC, that is dowry tax. When a lawman knows what is dowry tax, when some demand of dowry is there, and for that death is caused, somebody dies, that we treat that. But dowry tax has been defined in Section 304B of the IPC. What it provides, where the death of a woman is caused by any burn, bodily injury, either due to birth, by burn. Death of a woman is caused by burn, bodily injury, or otherwise than under normal circumstances. Otherwise than on normal circumstances. Normal death is not there. Within 7 years of a marriage, and it is shown, very important, and it is shown that soon before her death, these two words, soon before her death, interchanges the case. A woman dies, that is by burn, or by injury, or otherwise than on normal circumstances, within 7 years of her marriage. And it is shown that soon before her death, she was subjected to cruelty or harassment. Subjected to cruelty or harassment by her husband or by relative of the husband. By her husband and or by the relative of her husband, for or in connection with. For or in connection also makes the difference. For dowry or in connection with dowry. Any demand for dowry. For or in connection with any demand for dowry. Such death shall be called dowry death. And such husband or relative shall be deemed to have caused. A deeming provision is there. What is that? What are the ingredients? That is, the main, that is, section is that the death of the woman to not only be under any circumstance specified, but should be also be consequence of demand for them. That death must be for the due to town. So what it says, that is this section. If you go through the section very carefully, first a woman, death of a woman takes place. Death of an occurs. Death of a woman is caused by burn injury or by any other injury, burn or injury, bodily injury, burn or bodily injury, or otherwise than a normal circumstance. And it is shown that soon before her death, she was subjected to cruelty or harassment for or in connection with dowry. Or in connection with her dowry. By whom? By her husband or relatives of her husband. Any relative of her husband. Or in connection with any demand for dowry, such death shall be called dowry death. It is only defined what is dowry. Such death shall be called as dowry death, and such husband or relative shall be deemed to have caused death. In this context, you should know the provisions of Section 113B of the Evidence Act. What Section 113B? What it provides? That how there will be a presumption, all presumption in case of dowry death. What it provides? You see, 113B, presumption as to dowry death. What is presumption? When the question is whether a person has committed the dowry death of a woman, when the question is before the court, whether a person has committed dowry death of a woman, and it is shown that soon before her death, such woman had been subjected to such person to cruelty or harassment. The same words, the similar wordings are there. And it is shown that soon before her death, such woman was subjected to cruelty or harassment for with any demand for dowry. With any demand for dowry, the court shall presume that such person had caused the dowry debt. Your explanation for the purpose of this section, what is dowry debt? That shall be the same meaning as in section 304B of the Indian Penal Code. Same meaning as per Indian Penal. So here there is a shall presumption. Whenever court shall presume, the court shall regard such fact as court such fact as true, and until it is disproved, may presume, shall presume, and conclusive three definitions are there in the evidence act. Whenever it has been provided, directed, and declared. Three words. Whenever it has been provided in the Indian Evidence Act, the court may presume a fact. Court may regard such fact as true, or may call for proof. Second, whenever it has been directed, the court shall presume a certain fact. Court shall regard such fact as true until it is. When it is declared, one fact is the conclusive proof of another, then on proof of that fact, the court must regard that the other fact is true and will not allow any evidence to disprove. So these are the provisions in the Evidence Act. So now, what is dowry debt? That has been defined in section 304B. Dowry debt, you should understand it very carefully, that a death of a woman occurs. First, death of a woman occurs within 7 years of her marriage. First, and that death must be, or that death took place by burn or bodily injury or otherwise under normal circumstances. Third ingredient, that it is shown that soon before her death, what? She was subjected to cruelty or harassment or in connection of demand of dowry. Fourth, by whom? By her husband or any relative of her husband. Then that shall be then the said death will be called dowry death. And such husband, in such case, such husband or relative of the husband shall be deemed to have caused her death. Explanation provides for the purpose of this section. What is dowry? Dowry means, dowry as defined in section 2 of the Dowry Prohibition Act 1961. What is dowry? That there it has been defined, anything, any money given for marriage, even before marriage, at the time of marriage, and after marriage, for marriage of a woman. That will be treated as dowry. Then, subsection 2 says, whoever commits dowry debt shall be punished with imprisonment for a term which shall not be less than 7 years, but which may extend to imprisonment for life. So now you should know when this 304B was inserted. First, to curb the dowry, menace of dowry, in the year 1961, the Dowry Prohibition Act. Thereafter, it was felt the necessity of a drastic provision to check the dowry debt. Most of the death of the woman in many dowry deaths took place in different parts of our country. So, in order to check such for the dowry debt, in the year that is 1986, this Indian Penal Code, in Indian section 303 was included by amendment in view to curb the growing atrocities against women, where thousands of young women were being done to death due to failure to pay of the dowry demand. So young woman, a young man died because within 7 years of marriage. So the amendment also made a couple of consequential amendments. Not only that, because of this amendment, again there was amendment in the Evidence Act. And the Amendment Act has also made a couple of consequential amendments in the CRPC. In the CRPC, there is also amendment. That is 498A was included. That is cruelty to women. And also in the Evidence Act to make prosecution of offender in case of dowry death more effective. Not only in Indian Penal Code, but also in Criminal Procedure Code and the Evidence Act. Some amendments took place. That was in the Evidence Act, 113B was inserted. In the Indian Penal Code, 498A was inserted. So the essential ingredients, what are the ingredients? Death of a woman should be by burn, bodily injury, or the other than normal circumstances. First, such a death should have occurred within 7 years of marriage. Second, she must have been subjected to cruelty or harassment by her husband or any of the relative or husband. Fourth, such cruelty or harassment should be for or in connection with dowry or demand for dowry, not only dowry, demand for dowry. Such cruelty or harassment is shown to have been meted out to the woman soon before her death. Soon before is very crucial. Suppose 15 days back there was a quarrel, there was a demand, there was a harassment for a dowry, but after 15 days or after 6 months or after 1 month, the woman died due to burn injury. So that may not be dowry. So there must be some relationship that persuaded that the harassment or the cruelty that tempted the woman or that because of that some death took place. That is unnatural death took place. So the main component of Section 7 is that the death of the woman should not only be under the circumstances specified, but also be consequence of the demand of dowry. This is very important. Any property, what is dowry? Any property or valuable security, even valuable security, what is valuable? Valuable security means any document when a right is created, extinguished, etc. That has been defined in the Evidence Act. So any property or valuable security given or agreed to be given either directly or indirectly by any party to a marriage to the other party to the marriage. By any party to a marriage to the other party. That is that, or by the parents of either party to a marriage or by any other person to either party to the marriage or to any other person. This is dowry. Or before or any time after the marriage in connection. Before marriage, at the time of marriage, after before, after the marriage in connection with the marriage of the said party. Suppose this dower and meher that is given by the husband to the wife under the Muslim law at the time of marriage, that will not be treated as dowry because that is not dowry. But does not include because it has been provided in the Dowry Prohibition Act. It has been provided that but does not include dower or meher in the case of a person to whom the Muslim personal law applies. This explanation makes it clear. Then explanation for the removal of doubt, it is thereby declared that any person may at the time of marriage to either party to the marriage in the form of cash, ornament, clothes, or other article shall not be deemed to be dowry within the meaning of this section unless they are made as consideration for the marriage of the said parties. So voluntary presentation by the parents or any relative of this woman, that will not be treated as dowry unless they are made or as consideration for the marriage of the said person. So valuable security has been said meaning in section 30 of the IPC. That is in 30 of the IPC also that defines what is valuable security. So here there are number of living cases in this case. So what is dowry death? Soon before death is very crucial. Soon before means was the word that should be soon, that soon before or death, the woman was subject to cruelty or harassment by her husband or any relative or husband or in connection with the demand of dowry. In the word, it is crucial for the prosecution to establish that any cruel treatment or harassment was in close proximity, immediately preceding the death. Close proximity. There must be close proximity, that means soon before is a related term. And it will depend on the circumstance of each case. Each case, circumstances of each case is to be considered separately. A no straitjacket formula can be laid down as to what would constitute a period soon before the death. Soon before death, there must be some proximity. That means that this harassment is a cause for death. That should be proximity. Proximity that is very closely. That is between the demand, the harassment or cruelty for and demand of dowry. It would be hazardous to indicate any fixed period. No fixed period need to be judged in the light of the facts and circumstances of the case. The case differs from case to case. The importance of proximity case is both for the proof of an offense of dowry death as well as for raising a presumption under section 113B. Similarly, soon before death, that is presumption of the Evidence Act. The determination of the period which can come within the term soon before is left to be determined by the court. Soon before death, what is period? What is the time required? Whether the demand which had been made and the death which took place, there was a link. That is, courts should decide in each case, considering. It cannot be construed at any determined period of time that can be mechanically applied in each case, irrespective of its fact. So, what is the defense? As a lawyer, the first defense is that there may be demand for dowry, that is harassment or treating a woman with cruelty or harassment, but for dowry, for in connection, but that the demand must be within the link is there. Some link is there for the death. So there must be existence of proximity and live link between the effect or cruelty based on dowry, demand, and the concerned death. The alleged incident of cruelty is removed in time and had become stale enough not to disturb the mental equilibrium. If the demand was a very distant in time, that had not disturbed the mental equilibrium of the woman concerned, it will be of no consequence. So it is a very leading case of Chandra Pandey versus State. The accused married the deceased in January 1989. There were differences between them due to non-fulfillment of demand for dowry. The accused assaulted the deceased in June 1989 with an iron rod. Deceased went to stay with her parents. Thereafter, she returned to the house of her husband. In January 90, after some mediation between them by well-wishers. In March 1991, the accused left the deceased in her parents' house. After about a fortnight, she came back to the house of the accused. 2 days after that, she died. There was no material evidence to show that after her return in January 19, she had been subject to any cruelty or harassment for or in connection with it. For or, that is soon before her death. Very crucial disease. This changes the entire case. If prosecution is not in a position to prove that soon before her death, the woman was subjected to cruelty or harassment for or in connection with the demand of dowry, then that the dowry death allegation is fair, even if all these things are there. So now, 113B, you should know when the question is whether a person has committed dowry death, of a woman, and it is shown that soon before her death, such woman has been subjected by such person to cruelty by that person, or harassment for, or in connection with the demand for dowry, the court shall presume that such person has got such dowry debt. What is cruelty? Cruelty that is defined in section 498A of the IPC. If you go through the provisions of section 4, that is such a willful conduct which drives a woman to commit suicide, or which causes a grave injury, that will be also treated as cruelty. If you go to section 498A, you can know what is cruelty. It will be, you may know what is cruelty. Cruelty, that is 498A. This is also an offense against marriage. That is, what is cruelty has been defined? Any willful conduct which is of such a nature as is likely to drive the woman to commit suicide. That will be cruelty. Second, or to cause grave injury to a woman, or any danger to life, limb, or health. Any grave injury or danger to life, limb, or health, whether mental or physical of the woman, that will be treated as cruelty. Or these are all any willful conduct of such a nature as is likely to drive the woman to commit suicide, that will be treated as cruelty. Second, when somebody causes grave injury to a woman, that will be treated as cruelty. Any danger to life, that is, which causes any danger to life of a woman, danger to life, limb, or health. Danger to life, limb, or health, whether physical or mental of the woman, that will be treated. Or harassment of the woman, when such harassment is with a view to coercing her. Harassment, it is harassment. Harassment to the woman with a view to coercing that woman, coercing her, or any person related to her, to make any unlawful demand for any property. Here, dowry is not there. To meet any unlawful demand of any harassment to any woman, whether such harassment, when such harassment is with a view to coercing her, to create a pure psychosis in the mind of that woman, or any person related to her, to make any unlawful demand for any property or valuable security, or is on account of failure by her, even after failure, any harassment is given to that woman or any person related to her to meet such demand. This is what is cruelty has been defined. Cruelty. So here again on this valuable security has been defined in section 30 of the Indian Penal Code. How it is defined? You know, any document. Valuable security doesn't mean valuable property, valuable things, but valuable security is a document by which any right is created. You come to go through it. Valuable security, the word valuable decores a document which is or for the purpose to be a document. The word valuable security denotes a document which is or purpose to be a document, even said to be a document. Valuable security is a document which or purpose to be a document whereby a legal right is created. Signing is a valuable security. Signing a promissory note is valuable security. Whereby a legal right is created, extended, even right, because somebody's right is extended, or transferred, restricted, created, extended, transferred, restricted, extinguished, that is taken away, or released, or whereby any person acknowledges that he lies under legal liability or has not a certain legal right. This is valuable security. So that is why you should know valuable security, because here unlawful demand for any property or valuable security. Somebody says you obtain sells that land. Suppose the husband says like the wife, coerce her wife to get a sale deed registered in respect of the land, a particular piece of land of our father in his name. That will be also treated as valuable security. So this is 113B presumption. Then, so stone before a death is very, very important. Now, this is 304. 304B. 304B we completed. Now section section 305. 305 says, what is it? Abatement of suicide of child or innocent person. You know what is abatement? Any instigation or aid for to commit a person, a crime, a particular act. If any person under 18 years of age, any innocent person, any delirious person, any idiot, you see, a child below 18 years of age, any innocent person, or any delirious person, some mentally, some defect, delirious person, or any idiot. Idiot is a person who doesn't know, was no this proper, this intellectual development. A person may know who is a person who cannot count from 1 to 10. Idiot, or any person in a state of intoxicated person commits suicide. If such person commits suicide, whoever abated the commission of such thing, if somebody, this person, any of the person commits suicide, whoever abated such person to commit suicide shall be punished with death or imprisonment of life, or imprisonment for a term not exceeding 10 years, and shall also be liable to fine. Then 306 is abatement of suicide. If any person commits suicide, whoever abates the commission of such suicide shall be punished with imprisonment either death or a term which may extend to 10 years. That is abatement of suicide. Whoever abates a person, any person to commit suicide, that is punishable with a imprisonment which may extend to 10 years and shall also be liable to fine. What is the ingredient of this section? That is abatement. When abated a person to commit suicide, then he is liable for punishment up to 10 years. So here, in this context, you should know, somebody has written a letter in the recently that such and such person is responsible for my death. Whether that will be treated as abatement of suicide, that letter will not be sufficient, because what is abatement of suicide? There are many case laws. There must be abatement, instigation. That is, unless there is a person who is instigated, somebody to commit suicide, that will not be treated as abatement of suicide. That section 300 says, who attempt to murder, it is whoever does an act with such intention or knowledge or under such circumstances, does an act with such intention, knowledge or such circumstances, that he by that act cause death, he would be guilty of murder. A person, what is attempt to murder? That is 300. Whoever does an act with such intention, act is wrong, there is an intention or knowledge and under such three things. Doing an act with such intention is there. Not simply intention. Whoever does an act with such intention or knowledge and under circumstances, or knowledge and such and with such intention and under circumstances, or knowledge and under such circumstances that if he by that act caused the death, if by that he caused the death, he would be guilty of murder. If by that act he caused death, then he would be guilty of murder. That will shall be punished with imprisonment for either the state for a term which may extend to 2 years and shall be liable to fine. And if there is, and if hurt is caused to any person, while doing that act, if any hurt is caused to any person by such act, the offender shall be liable to either to imprisonment for life or to such punishment as is herein before mentioned. Attempts by life convict when any person offending under this section is under sentence of imprisonment for life, he may, if what is caused, be punished with death. This is unconstitutional. That is 303 is made unconstitutional. That is, yesterday we have discussed, that is Mithun Singh versus State of Punjab. So here, that is also divided. So what is, if somebody puts a attempt to commit suicide? You should understand this section. Somebody does an act with an intention or with the knowledge or and under such circumstances. If by that act he will cause death, if by that act he will cause death, then he will be guilty of murder. Then in such case, that will be treated as attempt to commit murder. Suppose X holding a star, holding a knife, or that attempted to stab on the chest of Y, but Y that took a side and so that X could not cause the injury. So in such case, that will be treated as an attempt to murder. Somebody holding a big bamboo at a bamboo lathi wanted to give a blow on the head of another person, but fortunately that person took a side and that person did not sustain the blow. When that person that went away, ran away to another place, so thereby he could not succeed. He was not successful to give that blow. But if that blow would have caused hurt to that man, he must have died. So in such case, that person will be guilty of murder. So that will be treated as attempt to murder. So here, somebody had attempted to commit murder. But the attempt could not that fulfill, or could not be effective. Or the attempt, in his attempt, he failed to cause the murder. He had attempted to cause somebody's death, and that if that death will be caused, that will be treated as murder. Then in such case, that act will be treated as attempt to commit murder. So here illustration will make you clear. A shoots at J with intent to kill him. Under such circumstances that if death ensues, A will be guilty of murder. A is liable to be punished under the section. A with the intention of causing the death of a child of tender years exposes it in a desert place. He has committed the offense defined by this section, though the death of the child does not ensue. Death of the child. Somebody wanted to, that means drive a vehicle on a person who was passing on the road intentionally, but that person ran away and he was saved. So that will be treated as attempt to murder. Intending to murder J, buys a gun and loads it. He has not yet committed the offense. Simply somebody has intended to cause somebody's death or commit murder. He simply purchased, he made a preparation. That will not be treated as attempt to murder. Intending to murder J, buys a gun and loads it. He has not yet committed the offense. He fires the gun at J. he has committed the offense defined in this. If in that fire you are successful to kill that person, then that will be treated as murder. So here, if by such firing you get, he wounds it, suppose by that firing some wound was caused, some injury was caused, some hurt was caused, then that is punishable with imprisonment for life. Offender shall be liable to imprisonment for life or to such punishment as is herein before mentioned, means that is with 10 years or which may extend to 10 years. That is, intentionally intending to murder Z by poison, purchases poison and mixes the same with food, either which remains in A's keeping. He has not yet committed the offense defined in this section. A places the food on Z's table or delivered it to Z's servant to place it on Z's table, he has committed the offense defined. Z's table, but Z did not take that food. Some other person took that food. Or that somehow that food that was wasted because that the plate fell on the ground. That is, in such case, he has committed the offense of attempt to murder. This section 307 deals with the offense of attempt to commit murder. In order to constitute offense under this section, two elements are essential. First, the intention or knowledge to commit murder. There must be an intention or knowledge to commit murder. Secondly, the actual act of trying to commit the murder. Actual act of trying to commit. Intention or knowledge to commit murder. Cause the death of a person which will be treated as murder, and he attempted to cause that act. Thus, it must have both the necessary menseria, because in menseria, actus, both things. For every offense, there is a menseria act. In other words, for offense under this section, all the elements of murder exist except for the fact that the death of the person did not occur. Except the fact that he could not cause death. Death was not. It is sufficient if there is present an intention to commit homicide coupled with some overact in execution thereof. You might have seen in the recent this farmers, that is case. Somebody was attacking police to cause hurt to the police, that is driving a tractor. So that attempt may be treated as this attempt to murder, because which intention is there, because somebody was standing knowing that he was was running the tractor to, that is, to kill him. So that is an attempt to murder. Act must be one culpable, capable of causing death. To sustain a conviction under the section, it is necessary to establish that had the accused succeeded in his attempt and the victim made to his death, then the offense committed would have been one punishable under section. That is, the death was caused, that is punishable on section 302. But if death is not caused, because in his attempt he failed to cause the death, that will be treated as attempt to murder. But intention, that is referred to the intention referred to in section 300, that is intention, this knowledge, as intention and the term knowledge under section 300, refer to knowledge as found in section 300. The term knowledge refers to the which are knowledge of the offender, that the act done by him is so immediately danger that it must be on probably caused death. Knowledge means so immediately danger that is not, or such bodily as is likely to cause death. Attempt, the question whether a certain act amounts to the commission of the particular offense is a question of fact that depends on the nature of offense and the steps necessary to take is under to commit it. So that is attempt to murder. Suicide, we have already discussed, but in section 306, there is recent decision, that is a suicide presumption, that is a suicide, abatement of suicide is there, and section 309, some change takes place in view of decision of the Honorable Supreme Court. That is presumption as abatement, similarly presumption In the next class, we will discuss the provisions and the case laws on section 309. That is, attempt to commit suicide. That is, attempt to commit suicide. It is no longer an offense. For that, this treatment should be given. That will be treated as insanity, and state should take steps for giving treatment to that person. That is, attempt to commit suicide. But whoever attempts to commit suicide and does any act towards the commitment of such offense shall be punished with imprisonment for a term which may extend to 1 year or with fine. In this connection, there are different case laws. And finally, now the law has been settled that when there is an attempt to commit suicide, the person who has attempted to commit suicide and he should be given treatment, or that will treating that is some mental disorder is there. Thank you. In the next class, we will discuss the provisions in section 309.